The highest court in the land, the High Court of Australia, has just ruled that media outlets can be sued over defamatory comments which are made by their audience, not by themselves, on Facebook. But we now know that it's not just the audience, the person who makes the defamatory comment, that can be sued. It's also the media outlet who unknowingly allowed the comment to be posted on their Facebook page. Now, this is a lawyer's picnic, another lawyer's picnic. It's now not a question of if the ambulance chasers will be out in packs firing off their expensive legal letters, their threats. It's a matter of when. Here at Michael West Media, we've had 3 in the past month alone. If we started picking up threats from people who'd posted on our social media, we'd be swamped, wouldn't have any time to do YouTube videos. Now, how did they come to this conclusion, the High Court? Well, the first thing to say is that the High Court can't be blamed for being old fuddy-duddies that don't understand the internet. That may be the case. The youngest guy is James Edelman, who's around 46, who's also said to be the most brilliant, but he wouldn't have been using the internet until he got out of school. They came at it because the High Court's role is not to make the laws, it's to interpret the laws and to make rulings or judgments about the law. And how do they do that? By looking at previous laws. So if you read this judgment, there's some great stuff in there. They refer to ancient cases in England, 20,000 miles away. Bullen and Leek's Precedent of Pleadings, 4th edition, Part 1, 1882, at page 390. Bromwich and Prosser, 1825, at page 255. Fisher versus Clement, 1830s. Bullen and Leek's Precedent of Proceedings, 4th edition, Part 2, 1888. That was about the time when polygamy was finally outlawed. There's been a lot of water under the bridge since then. Now, how did this case even come about? It came about because Dylan Voller, the kid that was abused in detention and then became an advocate for Indigenous rights, he brought a case. A High Court ruling was sought because people started making abusive comments, trolls started making abusive comments about Dylan Voller on the Facebook pages of the major media organisations, and so Voller's lawyers sought a High Court ruling on the matter. We don't begrudge Voller for 1 second his victory in the High Court. He deserves it. He has been insulted and abused in these forums. The problem is the unintended consequences of this ruling by the High Court, a ruling based on case law which goes back 200 or 300 years before the internet was even thought about. Now, our producer said a very interesting question when we were pondering yesterday, what do we do about this? Does this mean we have to shut down Twitter or shut down YouTube? Does this extend to Twitter, Reddit, Instagram, TikTok? Well, we don't know conclusively, and we can't just ring up. He said, can you ring the High Court to find out, to get a ruling? And I said, well, the only way to get a ruling would be to have a lazy $1 million at your disposal and seek leave to the High Court to appeal or to go and get a ruling. You can't just call up the Honourable Justice Susan Kiefel and say, g'day Sue, it's Mike from Manly here, just wondering whether, we can be sued for other people's comments on our Twitter feed. You can't do that. Judges don't talk to ordinary human beings like you and I. I mean, ad absurdum, if you look at this judgment and take it to its logical end, Scott Morrison could be sued for somebody else, let's just say Peter Dutton, making a comment which was defamatory on his Twitter feed. I mean, the implications are far-reaching. Let's just take the case of Jordan Shanks at the moment, who's being sued by John Barilaro, the New South Wales Deputy Premier. Or let's take Shane Barsey, the refugee advocate, who's being sued by Peter Dutton. Now they could potentially be held accountable legally for all the libelous comments made by other people they didn't even know on their feeds, as well as what they've said in the original publication. And you multiply that by everybody, not just public figures, but anybody commenting anywhere on a feed. You're already up for that, but now they can take out the publishers as well. This is a huge judgment in terms of its impact on media. big media as well as small. But of course, big media has the resources to moderate their various social media forums. Now, we've already seen public servants being sacked for tweeting things which aren't in the government interest, such as human rights abuses and so on. The next thing that's coming in are the cyberbullying laws. How far will they go? The cyberbullying is not a good thing, but it's also a subjective thing. It's a thing which will no doubt become the matter of many complaints once they bring in laws about cyberbullying. Free speech is a brutal thing, but it's also a completely necessary thing if you want the free passage of information in a democracy so we can all make decisions about what our elected representatives are doing. Now, the other point about this judgment yesterday by the High Court is that it will do nothing to address the pestilence of online trolls. They will merely drive decent small publishers, small businesses out of business, while the QAnons of the world, the fake special interest groups, the Cambridge Analyticas pushing shady agendas, the angry know-it-alls, they will simply take over. It does nothing either to address media concentration in Australia because, of course, big media will be able to afford legal representation. Now, there's been a flight to independent media because of the problem of media concentration and their alignment to the government in Australia. It's a threat to the democracy of information. But the unintended consequences are going to be absolutely enormous. Independent media is already thinking, and mainstream media is thinking about pulling all their commentary feeds, which will totally disengage them from their audience. It will ruin public debate. And who are the real beneficiaries? The lawyers, of course, because they will get more business. There will be more threats to be made, more law cases to be able to charge high legal fees. It will put the heat on ordinary people like you and I trying to have our say. It will enable wealthy and powerful people to use these laws to shut down adverse commentary and debate. The question is, do we want the internet to become simply the domain of ne'er-do-wells attacking people and people running shadowy agendas? Or do we want everybody, without fear or favour, to be able to have their say? The laws need to change. And Parliament is the only forum which makes the laws. The ball is now in their court. The only way we've been able to cope with the barrage of legal threats already is with your support. So we thank you, because this is a costly, resource-intensive exercise dealing with legal threats, and they're only going to increase. So if you can help us out with a few dollars on Patreon, thank you very much.